Welcome to Statute Stories. If you're looking to understand the law in a fun and engaging way, then you are at the right place. In this video, we will discuss sections 75 to 85 of the Pakistan Penal Code, PPC. So let's start. Section 76. Good faith actions and law protects honest mistakes. A person is not guilty of a crime if he does something because he genuinely believes the law requires him to do it, as long as this belief is based on a mistake of fact, not a misunderstanding of the law. Legal obligation. If someone does something because he is required by law, it is not considered a crime. Mistake of fact. If someone honestly thinks he must do something because of a factual mistake and not because he misunderstood the law, he is also not guilty of a crime. Illustrations. 1. A soldier fires on a mob by the order of his superior officer in conformity with the commands of the law. A has committed no offense. 2. An officer of a court of justice being ordered by that court to arrest Y and after due inquiry, believing Z to be Y arrest Z. A has committed no offense. Section 77. Act of judge when acting judicially. If a judge makes a decision while doing their job, acting judicially, and believes he is following the law, then he can't be accused of committing a crime for those actions. Imagine you're playing a game of cricket with your friends, and one of you is chosen to be the umpire. The umpire has special rules to follow, and as long as he sticks to those rules, they can't be blamed if someone loses or gets upset. Section 78. Act done under the judgment or order of the court. This rule means that if you do something because a court ordered you to do it, you won't get in trouble for it, even if the court made a mistake by giving that order. The key point is that you must believe the court had the authority to give the order and act in good faith. Example 1. Eviction notice. Imagine you're a landlord and a court tells you to evict a tenant. You follow the court's order and evict the tenant. Later, it turns out the court did not have the right to make that order. You won't get in trouble for evicting the tenant because you believe the court had the authority and you followed the court's order. Section 79. Acting in good faith. Legal protections for honest mistakes. It means that if you do something because you think the law allows you to do it and you make an honest mistake about the facts, you won't get in trouble for it. However, this only applies if your mistake is about the facts, not about what the law says. Example of self-defense. Imagine you are at home and you hear someone breaking in. You think it's a thief, so you defend yourself. Later, you find out it was a friend playing a prank. Since you honestly believed you were protecting yourself from a thief, the law protects your action. Example of property boundaries. Suppose you cut down a tree that you believe is on your property. Later, it turns out the tree was actually on your neighbor's property. If you made an honest mistake about where the property line is and you thought you had the right to cut the tree, you won't be in legal trouble. Section 80. Accident in doing a lawful act. This rule means that if you are carefully doing something legal and an accident happens, you won't get in trouble as long as you didn't intend for it to happen or know it could cause harm. Example 1. Car accident. Imagine you're driving your car within the speed limit and following all the traffic rules. Suddenly, a child runs into the street, and despite your best efforts to stop, you hit the child. Since you were driving legally and carefully and didn't intend to hit anyone, the law protects you from being charged with a crime. Example 2. Home repairs. Suppose you are fixing your roof and taking all safety precautions. A strong gust of wind blows some of your tools off the roof, and they accidentally break your neighbor's window. Because you are working legally and carefully and didn't intend for the accident to happen, you won't face criminal charges. Section 81. Balancing act and legal protection for preventive measures. It means that if you do something that might cause harm, but you didn't mean to harm anyone and you did it to prevent another harm, you won't be guilty of a crime. Example, breaking a window to save a child. Imagine you see a child locked in a hot car where gas is leaking and you break the window to rescue him. Breaking the window might cause harm, but you did it to prevent greater harm, the child overheating in the car. Section 82. Act of a child under 7 years of age. This rule means that if a child is under 7 years old, he cannot be charged with a crime for anything he does, no matter what it is. Example 1. Playground incident. Imagine a 5-year-old child accidentally pushes another child on the playground, causing them to fall and scrape their knee. Because the child is under 7, he cannot be punished for this action, even though it caused harm. Example 2. Broken vase. Suppose a 6-year-old child accidentally breaks a valuable vase while playing. Since the child is under 7, he cannot be held responsible for breaking the vase. Section 83. Act of a child above 7 and under 12 of immature understanding. It means that if a child is between 7 and 12 years old and doesn't fully understand what he is doing or the consequences of his actions, he cannot be charged with a crime. Example 1. Shoplifting incident. Imagine an 8-year-old child taking a candy bar from a store without paying for it because he doesn't understand that it's wrong or the consequences of stealing. Since the child is between 7 and 12 and doesn't fully grasp the seriousness of their actions, they won't be held responsible for shoplifting. Example 2. Doorbell prank. Suppose a 10-year-old child plays a prank on a neighbor by ringing their doorbell and running away. The child doesn't realize that this could upset or scare the neighbor. Because the child lacks maturity and understanding, he won't be punished for the prank. Section 84. Act of a person of unsound mind. This section means that if someone does something wrong but has a mental illness or condition that makes them unable to understand what he is doing or that it's wrong, he won't be considered guilty of a crime. Example: confused wanderer. Imagine a person with severe dementia wanders into a neighbor's backyard and starts picking flowers. He doesn't understand that he is trespassing or that taking the flowers is wrong due to his mental condition. In this case, he wouldn't be held responsible for his actions. Section 85. Unwilling influence. Legal safeguards for intoxicated individuals. This rule means that if someone does something wrong while he is intoxicated, but he didn't choose to become intoxicated and didn't know it was happening, he won't be considered guilty of a crime. Example: spiked drink. Imagine someone attending a party and unknowingly drunk spiked with a powerful drug. While under the influence, he causes damage to property in the party without realizing what he is doing. Because he didn't choose to become intoxicated and was unaware of the effects of the substance, he wouldn't be held responsible for his actions. Thanks for watching. Like, share, and comment. Follow for more videos. Take care. See you soon.